Secretary for Justice, Chairman of the Bar, President of the Law Society, fellow judges, distinguished guests, ladies and gentlemen. On behalf of the judiciary of the Hong Kong Special Administrative Region, I extend a warm welcome to everyone to this year's opening of the legal year. I'm grateful for the opportunity to address you on this occasion, particularly given recent events over the last 7 months that have concerned every person in our community. Many questions have been raised regarding the judiciary. Many commentaries have been given as to the work of the courts, and many views have been expressed regarding our judges. A lot of these have been fair, but unfortunately, some have proceeded on misconceptions and misunderstandings and distort an objective and proper picture of the law and the legal system. Some have even bordered on the unacceptable. Given the importance of the rule of law in the community, I would like to say something this evening about the concept of justice, the operation of Hong Kong's legal system, and the duties and responsibilities placed on the courts and the judges. Many of the misconceptions and misunderstandings arise following judicial decisions not to the liking of some people. I have said on a number of occasions that everyone is entitled to express their views regarding the work of the courts, and one cannot, of course, expect approval of the result in every case. However, when attacks are made against the integrity and impartiality of the courts, or against the soundness of the legal system, or personal and highly offensive attacks are made against judges based solely on the outcome of cases, something needs to be said to inform the community about the operation of the law. The rule of law is often said to be a core value in Hong Kong and a cornerstone of its success. In order to embrace this concept, it is important to understand how the law operates and is expected to operate. I start with the concept of justice. This is often discussed as an intangible ideal, but I wish to discuss the practical meaning of this. The basic law provides us with clear guidance as to what the law means to every person. It provides protection by setting out rights that enable a community to thrive, to allow members of society to live with one another, to live with dignity, and to enable members of the community to provide for themselves and their loved ones. The rights set out in the basic law and in our Bill of Rights, which is given constitutional backing by the basic law, include the freedom of speech, the freedom of association, of assembly, of procession, and of demonstration. We have seen these freedoms much exercised in the past 7 months, but it is important to understand that the enjoyment of these rights has limits, so as not to affect adversely to an unacceptable level the enjoyment by other members of the community of their rights and liberties. I have previously referred to this as a respect for other people's rights. Accordingly, we see clear limits in the law to the exercise of rights. The enjoyment or insistence on one's rights does not, for example, provide any excuse to harm other people or their property, or to display acts of violence. Our criminal laws provide a ready example of just where these limits lie, and when called upon, these criminal laws are enforced to their full and proper extent by the courts. The freedom of speech, called the freedom of opinion and expression in the Bill of Rights, states that the rights associated with this freedom carry with them special duties and responsibilities. Their exercise can therefore be restricted, for example, where necessary to respect the rights and reputations of others. The right of peaceful assembly is recognized, but are limited in the same way as the freedom of speech. So too the freedom of association. Therefore, the enjoyment of rights and freedoms also carries with it responsibilities, and it is simply not right to think that other people's rights or even the rights of the community as a whole, should somehow be regarded as less important than one's own. This acceptance is a large part of what I call the concept of justice. The administration of justice, or the practical way in which justice is dispensed in the day-to-day work of the courts, has as its central characteristic the requirement of a fair trial. Trials involve serious consequences. In the civil sphere, there may be significant personal or financial consequences arising from judgments of the court. In the criminal context, there are potentially extremely serious consequences if terms of imprisonment are imposed after conviction. A fair trial, accordingly, becomes essential. This is the fundamental requirement of the administration of justice and is reflected in the Basic Law. Article 87 of the Basic Law states that any person who is lawfully arrested shall have the right to a fair trial. Article 10 of the Bill of Rights reflects this by stating in terms that in the determination of any criminal charge or of rights and obligations in a suit of law, everyone shall be entitled to a fair and public hearing. There are many facets of a fair trial. I would like to draw attention to 4 such facets which have particular relevance in criminal proceedings. First, the presumption of innocence. This is protected by Article 87 of the Basic Law, which I have already referred to. This states not only that everyone is entitled to a fair trial, but that there is a presumption of innocence until conviction. This is repeated in Article 11(1) of the Bill of Rights. It is one of the fundamentals of our criminal law. Secondly, Article 12(2)(b) of the Bill of Rights states that anyone charged with a criminal offense will be entitled to have adequate time and facilities for the preparation of his or her defense. Thirdly, every person charged with a criminal offense is also entitled to be tried without delay. This is required by Article 87 of the Basic Law and repeated in Article 11(2)(c) of the Bill of Rights. This means that criminal trials ought to take place as quickly as practicable. Fourthly, every person convicted of a crime shall have the right to appeal both conviction and sentence. The prosecution may also appeal. The central requirement of a fair trial and its manifestations, which I've just set out, should firmly be borne in mind when viewing the activities of the courts in light of recent events. Views have been expressed, sometimes even criticisms, along the lines that there appear to be delays in the handling by the courts of cases that come before them. As I've said many times, anyone is entitled to make criticisms and comments about the work of the courts, and such are to be welcomed if improvements in the administration of justice can be made, but they must be on an informed basis. So far as cases related to recent events are concerned, one must bear in mind the constitutional requirement of a fair trial and the facets I've earlier identified. In a criminal case setting, the fairness of a trial means fairness to all sides, both to the prosecution and to the defense. In the vast majority, and I stress the words vast majority, of cases related to recent events, when they first go before the courts after arrests have been made and charges have been laid, the prosecution will request for time, often amounting to several weeks, if not more, in order to gather evidence, obtain legal advice from the Department of Justice as to the appropriateness of the charge laid, and then to decide the appropriate level of court to try the charge, whether the magistrate's court, the district court, or the court of first instance. At this stage, no pleas are taken, and out of fairness to the prosecution, it will be allowed time to prepare its case. Once it has done so, all relevant prosecution materials will then be provided to the accused person, who must also be afforded adequate time to consider and prepare his or her defense. When both the prosecution and the defense are more or less prepared, pleas are then taken, and if charges are contested, a trial date is fixed in the chosen level of court. As early a date for trial as is practicable is then given. All the aspects of a fair trial that I've referred to earlier are relevant when dealing with recent cases, as they are in every criminal case dealt with in our courts. The court will at all times ensure that a fair trial takes place. And when accused persons have to wait for trial, the question of bail arises, and in this context, the law is clear. Bail is normally to be granted unless some exceptions apply, such as the risk of flight or the risk of witness tampering. This is entirely consistent with the presumption of innocence. The approach of the courts is not to presume an accused guilty. Constitutional principles mandate the opposite. Where persons are convicted of crimes, the question of sentencing then arises. This is also an exercise based on the application of legal principle applied to the circumstances of the individual case. It is not an arbitrary exercise. Legal principle in this context includes looking to the sentencing guidelines set by the courts, in particular the Court of Appeal, and due recognition is given to the factors of retribution, deterrence, prevention, and rehabilitation. As with all other work undertaken by the courts, sentencing involves the careful application of the law and legal principle. And after the outcome of criminal trial, if either the defense or prosecution is dissatisfied with the result, there is the availability of an appeal in accordance with the law. What I have just said provides a relevant context when evaluating the work of the courts, particularly in relation to those cases which relate to recent events. While expedition is desirable, there are other factors that must be taken into account in the proper administration of justice. A fair trial does not mean that there must be a conviction or an acquittal, depending on one's personal or political viewpoint. The outcome of a criminal trial depends on the evidence that is presented to the court, whether it is sufficiently cogent, and whether the burden of proof beyond a reasonable doubt, has been discharged by the prosecution. I'm of course aware of the volume of cases that are before the courts relating to the events of the past 7 months. I've already mentioned that in the vast majority of cases, the prosecution will request for time to gather evidence and to obtain advice on the appropriate charges to lay in the desired level of court. The vast majority of cases are at this moment simply not ready for trial. That said, in order to cope with the expected high volume of cases, the judiciary has made plans to deal with such cases at whatever level of court expeditiously. A task group has been set up for some time now to look into how best and how expeditiously our courts can cope with these cases. Relevant stakeholders will be consulted on suggested measures. These include proposals to sit extended hours. I must, however, emphasize that while expedition is desirable, and we will do our best to achieve this, it is important to bear in mind the overall importance of a fair trial. The proper administration of justice depends on judges discharging the duties and responsibilities incumbent on them. This is often misunderstood. Judges do not have the duty to achieve a certain result in accordance with popular wishes, whether they be majority or minority wishes. However, they have to ensure that a fair trial takes place and to adhere strictly to the requirements of the law. This is critical to bear in mind. In the discharge of their responsibilities, judges look only to the letter of the law and to the spirit of the law and nothing else. Political, economic, or social considerations, as opposed to legal considerations, simply do not enter into the equation. If the courts have erred in their application of the law, then, as I've just mentioned, there is a system of appeals all the way up to the Court of Final Appeal. The duties and responsibilities on judges, as I've just outlined, are constitutional duties and responsibilities. The basic law states that the courts exercise judicial power. The exercise of judicial power means that all judicial decisions are based on the law and nothing else. Article 92 of the Basic Law states that judges are only chosen on the basis of their judicial and professional qualities. The judicial oath, which Article 104 of the Basic Law states must be taken, requires all judges to uphold the basic law and conscientiously, dutifully, in full accordance with the law, honestly and with integrity, safeguard the law and administer justice without fear or favor, self-interest or deceit. There can be no compromising of these fundamentals. Included in the judicial oath is the theme of the independence of the judiciary. Article 85 of the Basic Law states that the courts of the Hong Kong Special Administrative Region shall exercise judicial power independently, free from any interference. This means exactly what it says. The simplicity of the concept must not detract from its paramount importance in the way judges are required to operate and fulfill their constitutional duties and responsibilities. The task of the courts is to resolve legal disputes in accordance with the law. Everyone is subject to the law, no one is above it. The guarantee and requirement of equality, which is also clearly spelt out in the Basic Law and the Bill of Rights, ensures that everyone, high or low, public body or citizen, are subject to the law and answerable to it. There are no exceptions. The duty on the courts to enforce the law is a constitutional requirement of the Basic Law. I can say with confidence that my fellow judges and I will discharge our duties without compromise and without fear. An independent judiciary does not mean it is not accountable to the community. Of course, the judiciary and its judges are accountable, but it is of critical importance to understand the duties and responsibilities of our judges. A proper understanding of the concept of justice, the administration of justice in Hong Kong, and the duties and responsibilities of judges will enable anyone to comprehend and appreciate the value of the rule of law. These components of the rule of law, in particular, the independence of the judiciary, are all referred to and clearly guaranteed under the Basic Law. They are also constants in the way the law operates, in good times, in not so good times, at all times. Today marks the final occasion I will be addressing you at the opening of the legal year, as I will be retiring when I reach retirement age in January next year. There is still much work for me to complete, but I wish to say this. It has been the greatest privilege of my professional life to be Hong Kong's second Chief Justice. I hope you will allow me to make 2 points before I leave this stage for the last time. First, I want to thank sincerely and from the bottom of my heart my judicial colleagues in the judiciary. They have over the years given me unwavering support. More important, they have done their utmost to maintain the rule of law in Hong Kong and to honor their oath, as I myself have tried to. And there is no doubt they will continue to do so under the leadership of my successor. They discharge their duties and responsibilities with dedication and courage, and they do so notwithstanding that times may be challenging and notwithstanding criticisms that may be made against them. I also want to express my deep gratitude to all staff within the judiciary. They have likewise given me wholehearted support over the years. They have shown dedication in the face of unprecedented challenges. I thank you all, judges and staff alike, and I will miss you. The second point is a simple message. The rule of law is rightly cherished by the community and is the foundation of a cohesive society. We must do all our best to preserve it and to treasure it, because once damaged, this is not something from which our community can easily recover. I will always be committed to this. I'm also fully confident that the community remains committed to the rule of law in Hong Kong. Lastly, I wish all of you and your families a fulfilling 2020 and a happy and peaceful Year of the Rat. Thank you.
Chief Justice, members of the Judiciary, Chairman of the Bar Association, President of the Law Society, distinguished guests, ladies and gentlemen. This is a time of reflection on the past year and also to plan ahead. The state of turmoil in Hong Kong in 2019 has put us through the most difficult times. Many of the core values in Hong Kong have been under challenge, and the core value closest to our hearts, the rule of law, is no exception. There are many intimations of what constitutes the rule of law. Some may be described as perpetual truths and inspirational, whilst others imaginative or even misleading. There are many ways by which the practice of the rule of law is to be assessed, some based on subjective perception, while others on objective indicia. Two authoritative statements inform us the correct concept. The late Lord Bingham's inspiring book, The Rule of Law, summarized the core value as all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect, generally, in the future and publicly administered in the courts. The declaration of the high-level meeting of the United Nations General Assembly on the Rule of Law at the national and international levels in 2012 recognized that the advancement of the rule of law is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms. Given the broad perspective that the rule of law necessarily entails, I seek to highlight some of its substantive and procedural aspects. As held by Lord Diplock, the acceptance of the rule of law as a constitutional principle requires that a citizen, before committing himself to any course of action, should be able to know in advance what are the legal consequences that will flow from it. The law must be accessible, intelligible, stable, predictable, and fair for the sustainable development of any society. In Hong Kong, our legal infrastructure is set out in the Basic Law. Our legislation is in plain language and accessible at the HKEL website. Our case law is also readily accessible to the public on the internet. Litigation invariably involves competing rights, yet rights are not necessarily absolute and may be subject to restrictions. As the Court of Appeal stated in the Secretary for Justice versus the Wong Chi-fong and others case, if the individual's rights are overemphasized at the expense of observing the law, people will easily become self-serving with little regard for other people's rights and the overall interests of society, so that society is prone to fall into disarray. When disarray, such as unchecked acts of violence and vandalism, prevails, it will be rule of mob, not rule of law. In ordering the continuation of an interim injunction to restrain doxing and harassment against police officers on internet-based platform, the High Court reminded that the promotion and maintenance of the rule of law is not sensibly and rationally pursued by repeated and escalating breaches of the law, and persons who commit such crimes are simply and properly described as criminals. Criminal activity does not cease to be criminal activity simply because the actor believes himself or herself to be acting for a particular, perhaps higher cause. In the Crown versus Caird and others, Lord Sachs also held this: any suggestion that a section of the community strongly holding one set of values is justified in bending together to disrupt the lawful activities of a section that does not hold the same views so strongly or which holds different views cannot be tolerated and must unhesitatingly be rejected. Fair trial and due process are essential elements of the procedural aspects of the rule of law. The judiciary plays the pivotal role. As observed by Chief Justice Ma in the International Rule of Law lecture of the Bar Council of England and Wales back in 2015, a transparent system of law in which the community can observe that the independent judiciary administers justice without fear or favor, self-interest or deceit, with reasoned judgments available as evidence that the adjudication is in accordance with the law and its spirit, indicates the existence of the rule of law. Lord Neuberger's holding on the role of the judiciary in the Brexit case completes the analysis. In the broadest sense, the role of the judiciary is to uphold and further the rule of law. More particularly, judges impartially identify and apply the law in every case brought before the courts. In 2019, the department continues to provide honest, independent, and professional legal advice on a wide spectrum of matters to the government so that it is fully appraised of the legal implications and acts strictly in accordance with the law. Apart from representing the government in public law litigation and civil claims, the department endeavors to ensure that government policies and legislative proposals comply with the basic law as well as other fundamental principles of our legal system. The department also takes seriously its constitutional role of controlling criminal prosecutions free from any interference under Article 63 of the Basic Law, and all prosecutorial decisions are made after taking into account the available evidence, applicable laws, and the principles set out in the prosecution code. To facilitate more convenient access of the laws of Hong Kong, the department continues to enhance the HKEL database with more laws as verified version published on it. On top of that, we have taken a number of new initiatives, and in the interest of time, only a few will be mentioned here. The inaugural annual Hong Kong Legal Week was held in the first week of November 2019 with participating legal experts from over 30 jurisdictions. This year, 2 examples showcase the unique benefits of one country, 2 systems policy to Hong Kong. First, the game-changing and groundbreaking arrangement between Hong Kong and the mainland concerning mutual assistance in court-ordered interim measures in aid of arbitration proceedings. It capitalizes on the national policy of China in its outline of the 13th Five-Year Plan and recognizes the difference of the 2 systems in the legal and arbitration context. This arrangement has made Hong Kong the first and only jurisdiction outside mainland China where, as a seat of arbitration, parties to arbitral proceedings administered by eligible arbitral institutions can apply to the mainland courts for interim measures. The second is the arrangement between Hong Kong and the mainland on reciprocal recognition and enforcement of judgments in civil and commercial matters, which was concluded in January 2019. The scope of the enforcement of this arrangement goes beyond the Hague Judgments Convention of 2nd July 2019. Once in force, Hong Kong will be the only jurisdiction where certain intellectual property-related judgments would be enforceable in the mainland. With the support from the Central People's Government, the Department entered into a Memorandum of Understanding with the United Nations Commission of International Trade Law during the legal week to confirm the co-organization of the Asia-Pacific Judicial Summit on a biannual basis and to explore further collaboration. In the wake of the promulgation of the outline development plan of the Greater Bay Area, the legal departments in the Guangdong Province, Hong Kong, and Macau established a joint conference mechanism in September 2019 to work on projects of mutual interest at the government level. Other initiatives of the department include co-organizing with the Hague Conference on Private International Law, the inaugural Global Conference on the Hague Judgments Convention concluded last July, and exporting the Hong Kong brand Mediate First to other jurisdictions. The vast amount of professional work and the initiatives of the department would not have been possible without the dedication and hard work of my colleagues, for which I am most grateful. 2020 marks the 30th anniversary of the proclamation of the Basic Law under the Constitution of the People's Republic of China. The department will organize a conference to commemorate this. Other new initiatives include the organization of intergovernmental meetings and conferences to enhance our international stature. Importantly, the department will launch a 10-year project entitled Vision 2030 for Rule of Law. This initiative seeks to promote the proper understanding and recognition of the rule of law by studying its various elements through research, stakeholders' collaboration, and capacity building, thereby contributing to the sustainable development of inclusive and fair societies at both the domestic and international levels. Given this will be the last time for Chief Justice Ma to host the opening of the legal year before his Lordship's retirement in January next year, I would like to, on behalf of the department, convey our sincere appreciation for his Lordship's contribution to the rule of law and his efforts in retaining and attracting talent of the highest professional quality for our judiciary to administer justice. Last but not the least, a happy and peaceful new year to you and your families. Thank you very much.
Chief Justice, judges, magistrates, the Secretary of Justice, President of the Law Society, distinguished guests from overseas law societies and bar associations, ladies and gentlemen. You do not need me to tell you what an extraordinary year has just ended. A fair number of you would have participated in one or more of the mass demonstrations to show discontent with the Hong Kong government. Even more of you would have seen these protests on television screens or on social media. All of you will, I hope, have despaired when you saw serious violence breaking out, which saw some people attacking and injuring others, whilst others committed acts of criminal damage. Such activities cannot come within the exercise of the right of peaceful protest. There will be a reckoning later this year for some of the people. The police arrested several thousand people coming from all walks of life. The arrested persons are predominantly young, some are just school children, many more are university students, however, many more were ordinary workers and others had stopped working a long time ago and entered retirement. Some of these people now face serious charges which carry substantial terms of imprisonment. Many, though, have been charged with lesser public order offences not involving violence or extreme vandalism. They are, all of them, in the main, of good character. They are, in fact, representative of a large section of Hong Kong society. It's not for me to advise the Secretary of Justice about who she should prosecute and for what offences. Article 63 of the Basic Law says the Department of Justice controls criminal prosecutions, and I quote, free from any interference. However, the prosecution code published by the Department of Justice reminds us that a decision to prosecute is not made just because the police have enough evidence to go to court and secure a conviction. Public interest plays a part in the decision-making process too, so that individuals or some classes of cases will not end up in court, even though there is a strong case against them. To some people, a decision not to prosecute when there is evidence which will secure a conviction may appear odd and at variance with the rule of law, which some people mistakenly think calls for a prosecution whenever the law appears to have been breached. That is an incorrect understanding. The prosecutor is looking beyond the four corners of a charge sheet to other matters, both personal to the person charged and to other matters, is a part of the rule of law. In 2006, the Court of Appeal here described this prosecutorial independence and the ability to look at overall merits of a case before deciding a decision-making to prosecute as constituting a linchpin of the rule of law. I believe there will surely be a winnowing of cases going forward to prosecution. There will, though, still be many hundreds of cases, if not thousands. They will have to be processed through the courts by judges and magistrates, with lawyers from the Department of Justice, the Bar and the Law Society playing a necessary part as either prosecutors or as defence representatives. It will be a formidable task. I'd hope that the new Bar Council will look to ways in which it can help in encouraging members to provide those services in future trials. That may mean reminding some members who have not practiced criminal law for a long time that they should brush up their skills and be prepared to help out in court so that fair trial rights, which apply to both the prosecution and the defence, may not be jeopardised. At this stage, I should pay tribute to the barristers who, working together with members of the Law Society, have provided legal assistance at police stations and magistrates' courts to persons arrested for public order and other offences. One day we'll see scores of arrests and people taken to police custody, and the next day there'll be more of the same. Police stations often could not accommodate the detainees, and the subsequent dispersal to other police stations and detention facilities presented members with significant challenges to track down their clients and to see them. Later on, these barristers will be in court with the arrested persons, in some cases waiting until 8 or 9 o'clock at night before their clients' cases came on. Only by brilliant organisation of some and enthusiasm and hard work of all concerned could the arrested person's constitutional right to see a lawyer and be represented be made safe. When later on these cases arrive in court for trial, there will be decisions that are bound to please or disappoint the participants, as well as persons who follow the cases. Sometimes stronger emotions are aroused. We have seen judges abused and vilified only recently. The reaction has been because a verdict or a sentencing decision has not met the expectations of people outside the judicial process who have a view on what should be the correct disposal of a case. The Chief Justice has said it before now, but it needs repeating. Judges do not try people differently because of the defendant's political or other beliefs. If they were to do that, they were not true to their oath of office, which bound them to do justice without fear or favour self-interest, or deceit. I wish that the words of the US Supreme Court Justice Samuel Alito were more widely known and, more importantly, accepted and understood, which are these. A judge can't have any preferred outcome in any particular case. The judge's only obligation, and it's a solemn obligation, is to the rule of law. Similarly, barristers are not allowed to let personal prejudices get in the way of providing representation to persons seeking to use their services. We have a rule in our Code of Conduct that's called the cab-rank rule. It requires barristers to act in any case in the area of law in which they practice in return for the usual fee. They must act irrespective of what they make of the client's character or his or her beliefs. The cab-rank rule is regrettably a rule that, like most regulations, is dull to read. But an English barrister from the 18th century, Thomas Erskine, stated the essence of the rule in a scintillating speech when he defended Thomas Paine in 1792. And I pause here because I know the Dean of the Faculty of Advocates in Edinburgh is in my audience. And of course, Erskine was a Scot, and all Scots advocates are the best at the English bar. Thomas Paine was a radical. He wrote a book which suggested that it was lawful for people to overthrow a government which failed to protect their natural legal rights, such as freedom of thought, assembly, and speech. The Attorney General charged him with sedition, that's to say, with exciting disaffection and hostility against the government of the day. Other barristers attempted to persuade Erskine not to take up the case because Paine was absolute poison to the government. Defending him would blight his chances to do government work because he would forever be associated with Paine and his politics. Erskine later told the jury about the pressure he came under from his fellow lawyers not to defend Paine. He said, "From the moment that any advocate can be permitted to say that he will or he will not stand between the Crown and the subject arraigned in the court where he daily sits to practice, from that moment, the liberties of England are at an end." Erskine lost the case, not surprisingly, but his stubborn and principled defense of Thomas Paine so enhanced his reputation as a barrister who championed independence of the profession that 14 years later he became the Lord Chancellor. The principle encapsulated in that part of Erskine's speech holds good today, here and now. Barristers will continue to defend unpopular clients and causes, not because they necessarily want to do so, but because it's their professional duty. I should not like to see the bar have to comment again on other incidents like the one which occurred last September, when a crowd hounded a prosecutor in the High Court building for doing his job in opposing a bail application made by a young person arrested during the protest. In 1990, the 8th United Nations Congress on the Prevention of Crime and the Treatment of Offenders adopted a document called Basic Principles on the Role of Lawyers. Paragraph 18 states that lawyers shall not be identified with their clients or their clients' causes as a result of discharging their functions. This principle, in this day and age, needs to be understood and accepted too. These are some of my misgivings for the years to come. I hope that they do not come to pass. If they do, I believe I can assure the Chief Justice that the Bar will, as ever, assist in helping the judiciary to discharge its solemn responsibilities under the basic law. It remains for me to wish you all better fortune in the year and a happy year of the rat. Thank you.
Chief Justice, Secretary for Justice, Chairman of the Hong Kong Bar Association, members of the judiciary, members of the legal professions, distinguished guests, ladies and gentlemen. On behalf of the Law Society of Hong Kong and its members, I extend a warm welcome to all our guests who attend this opening of the legal year ceremony. Some of our guests may have attended this ceremony routinely for decades. For some, it may be the first year they attend this ceremony. They may wonder why this parade of our distinguished judges all robed with medieval costumes. If you come to this hall thinking that you are attending a fashion show, a drama, or an opera, you may like to have your money back at the ticket office outside. I am not sure whether our judges have good fashion sense or whether they sing well. But what I know is that our judges have good sense of justice, and they pronounce independent and sound judgments. I have been reflecting on the purposes of the opening of the legal year ceremony, and I come to realize that this ceremony serves a very important purpose of sending a strong message to our community that our judiciary is fiercely and totally independent and its integrity is beyond doubt. Our judges do discharge their duties in full accordance with the law, honestly and with integrity, safeguard the law and administer justice without fear or favor, self-interest or deceit. For that, they deserve our greatest respect. Judicial independence is one of the fundamental core values in our civil society. It is also one of the fundamental attributes of a society which is governed by the rule of law. I can proudly say to the public, our community at large, and our international community, that our judiciary is totally independent. Our citizens must appreciate that our judges decide cases according to the law, not according to any, I emphasize the word any, extrinsic factors, or any color codes, also known as political views nowadays. Baroness Hale recently warned against the UK from adopting a US-style Supreme Court. I cannot agree more. This is the time to tell the public that politically, our judiciary is colorblind. Nonetheless, our judiciary deserves our citizens' protection when under unfair attacks. Of course, members of a profession have a non-delegable duty to defend our judges when they are unfairly attacked. But what is more important is that our citizens must appreciate that it's equally their duties to defend our judiciary. Some may not like the outcome of the decision of judges. We have appellate bodies. Rational and healthy criticisms are welcome, but any unfair and unfounded attacks purely according to the outcomes and political views cannot be tolerated. On 4th July 2018, the Law Society and the Bar Association jointly issued a statement, and I quote, "The Law Society of Hong Kong and the Hong Kong Bar Association urge members of the public to express their views in a manner conducive to rational debate. Personal attacks on judges have no place in rational discourse and debate. That is a hallmark of a civil society." More recently, on 2nd of January 2020, the Law Society of Hong Kong and the Hong Kong Bar Association had to issue yet another public statement, and I quote, "Any attempt to insult, threaten, or bring public pressure on a judge because of decisions made in the course of performing judicial duties is to be deplored as an affront to the rule of law and judicial integrity. In Hong Kong, we are fortunate to have a sound legal system and an independent judiciary for our practitioners to deliver their professional services. It is our duty to defend our value system and its reputation. Distinguished speakers have spoken time and again on the importance of the rule of law. I should not repeat the same, say that I would like to point out an obvious fallacy that one can uphold the rule of law without obedience of the law. It might seem trite that obedience of the law is non-negotiable and uncompromisable. Arson and injuries to persons can hardly be justified on whatever political basis. Another fundamental core values in our community is respect of others' personal and property rights. With utmost respect, civil disobedience is no license to arson, damage to citizens' properties, and injuries to persons. Lest it be forgotten that obedience of the law, safeguard of the law, are not only our duties, but our core values. Unless we want to resort to some medieval method of dispute resolution, for example, trial by combat. Every willful disobedience of the law is an erosion on our rule of law. I do not subscribe to the view that the rule of law will not be affected if those who committed arson and injuries to persons are willing and would eventually pay the price by going to prison. Humanity dictates however strong we may disagree with others' political views. In a civilized society, we cannot resort to violence to silence different views. Hong Kong is a small city, but it is big enough to embrace different views and values. Madame Roland, a French revolutionary, once famously said, "Oh, freedom, what crimes are committed in your name?" Basic human decency dictates that we cannot persecute others simply because they take a different political view. We must be guarded against the ironical trap of infringing others' freedom in the pursuit of our own freedom. Hong Kong is still a most open and free society. Hong Kong consistently ranked #1 in the Index of Economic Freedom by the Heritage Foundation. In terms of legal services, Hong Kong's legal market, in particular the solicitor branch, is extremely open and international. We warmly welcome foreign law firms to set up their offices in Hong Kong. As at the end of 2019, we have 91 registered foreign law firms and 1,688 foreign lawyers from 33 jurisdictions. And 106 overseas lawyers were admitted in 2018 as Hong Kong solicitor through passing the overseas lawyers' qualification examination. Hong Kong is designated to be an international legal hub in the region. I am confident that with the quality and integrity of our professional members, the judiciary and the legal community, Hong Kong will meet its challenges and continue to contribute to humanity by it being a passionate and yet rational society. In the beginning of the year 2020, I would like to take the opportunity to wish you all a 2020 vision for all your endeavors and a very prosperous and healthy new year. Thank you.